An emergency, according to the constitutionary, is a circumstance that is really threatening. If the Yang Tak Agung is justified that a serious emergency is occurring in the Federation or any part thereof, then the Yang Tak Agung may issue a proclamation of emergency with a proclamation to the effect according to Article 150 Clause 1 of the Federal Constitution. The proclamation of emergency under Clause 1 can be made before this actual incident according to Article 150 Clause 2. This explains why, in the event of disaster, storm, haze, or political chaos in the country, an emergency can be proclaimed.
On September 1997, the Prime Minister Dr. Mahathir Mohamad has declared an emergency for the entire state of Sarawak, which affected the entire country. For example, the issue of closure order for all government and private offices and other workplaces, factories, farms, and others. As previously stated, the press has stressed that only this will started not with acts of parliament. So this subject is only investigated as an extended political topic or issues that is utterly technical in nature. Both legally and in terms of the subject and study of political science, this is a significant issue to consider.
One is an example of a constitutional event that had a major effect on the country's history and politics. It can be related to the case of Stephen Kananikan versus Tun Abang of 1966. A Sarawak court case can be linked to this concept because it involves Nikan's removal from his position as Sarawak's chief minister. Nikan brought the case to the court. The judges said that the only effective way to remove the chief minister is through a vote in the legislature. On 14 September, the state of emergency was declared. Section 155 of the Emergency Act 1966 asked the government to call a meeting of the State Legislative Council to seek a vote of confidence in Nikan.
Nikan was subjected to a vote on September 23, 1966 to determine the level of trust that the people had in the government. Nikan was removed from his position as Chief Minister. Despite the fact that the emergency is only temporary, there is no guarantee that it will continue. It has the potential to put the constitution in jeopardy. When the Yang-Pertua Agong acts on or considering the advice of the cabinet, this clarifies that his action is an action of the federal government, not on his own authority. He acts on advice and after taking into consideration the cabinet's advice. To summarize, these constitutional changes and problems must be resolved, not only by referring to the Constitution's substance, but also by applying relevant principles to the situation. That's all from us. Thank you.